Good morning. Can the folks at the jail hear me okay? Good morning, gentlemen. All right, good morning again, everybody. I'm Judge Colaw, and this is Injunction Court. I know you just watched a video that explained much about this process and how it will work today, but I do want to go over some things with you before we get started. Some of them may be repetitive, but they're nonetheless important, so I appreciate your attention while I do that. I'm going to be conducting hearings this morning on cases involving domestic violence, repeat violence, dating violence, sexual violence, and/or stalking. And based upon the evidence that's presented today, I'll be determining whether or not an injunction will be entered, extended, or dismissed. If I do enter a permanent injunction against you, then respondents, make sure you read through it, become familiar with its terms, conditions, and duration. If you have any questions whatsoever, then please clear those up before you leave the courthouse today, because you will be required to strictly comply with all terms and conditions of any injunction entered by the court. It is possible that some of the respondents have been arrested or charged with a criminal case arising out of the same facts that form the basis for today's injunction. If that is the case, then there are a couple of very important things I need to go over with you. The first of those are your rights. Each of you have the right to remain silent. Anything you say today can and will be used against you in your criminal case. Please do not construe anything that's happening here in this court as a requirement that you testify and potentially give evidence against yourself. If you wish to be heard today about the basis for this injunction, then I'm happy to give you that opportunity, and I will listen to your testimony, but you need to do so with a full understanding of your rights in mind. Everything being said in this courtroom is being recorded, and what you say can be taken and used against you in your criminal cases. Second, if you've been arrested or charged with a domestic violence crime, then you likely have a no contact with the victim provision as part of your criminal case. And that was likely imposed as part of your bond or release conditions at your first appearance in that criminal case. The victim is likely the same person as the petitioner in this case. And if so, it's critical for you to understand that this is civil court and that's criminal court, and they are independent of one another. So, for example, if I were to dismiss the injunction today in this court, you would still have a no contact provision with the victim in place in your criminal case. That's critical for you to understand, because if you violate that no contact order in your criminal case, you can be charged with a new crime, a first-degree misdemeanor punishable by up to 1 year in the county jail. If I enter a final injunction against you today, it's also going to require that you have no contact of any kind with the petitioner. So I don't have to explain what no contact means to this court multiple times. Let me be clear about what it means right now. It means no contact of any kind whatsoever. That includes direct contact with the petitioner, and it includes indirect contact of any kind with the petitioner. You can't send messages through third parties, friends, or family members that are intended to find their way to the petitioner. You cannot contact the petitioner through telephone or text message, through a computer or email, through social media websites such as Facebook, MySpace, Twitter, Pinterest, or whatever the next social media platform is. And finally, if you arrive at the same public place or social gathering and the petitioner is already present at that location, you must leave that area immediately until they are no longer present. Now, if you violate the no contact provision of the injunction, you can be charged with a criminal offense, a first-degree misdemeanor punishable by up to 1 year in the county jail. If you repeatedly violate the no contact provision of the injunction, you can be charged with aggravated stalking, which is a third-degree felony punishable by up to 5 years in state prison. If I enter a permanent injunction against you today, then respondents, federal and Florida law make it unlawful for you to purchase or possess a firearm, and that includes a rifle, revolver, or any ammunition for any firearm. Petitioners, if I enter a permanent injunction in your favor today and you need additional copies, whether that be for employers or schools, just let the clerk know how many copies you need and we'll make sure you're accommodated. It's the petitioner's and the respondent's responsibility to update your mailing and contact information with the clerk if that changes after today. If you fail to do so, then you may miss out on an opportunity to receive notice of, be present, and be heard at a future court event related to this injunction. Now, when I call your case this morning, here's how it's going to work. I'd like the petitioners to come up to the podium on my right. I would like the respondents to come up to the podium on my left. The first thing I'm going to do is place you both under oath. All testimony you give to the court today will be under oath, and any person who knowingly gives false testimony under oath could be subject to a perjury charge, which is a third-degree felony punishable by up to 5 years in state prison. Now, the first thing I'm going to do is ask the petitioners if they still want to go forward with their request for an injunction. If you do not, then simply tell me that. I may ask a few brief follow-up questions, but then you'll be free to go about your business today as soon as you get a copy of my final written order. If you do want to go forward with your request for an injunction, then respondents, I will turn to you and ask you whether or not you're in agreement with an injunction being entered against you today, or whether you wish to proceed to a hearing. Now, you can be in agreement with an injunction being entered against you without admitting to any of the underlying facts contained in the petition for the injunction. And if you are in agreement with an injunction being entered against you, simply let me know that's the case, and I'll be happy to enter it, and you'll be free to go about your business today as soon as you get a copy of the written copy of that final injunction. Now, if we do proceed to a hearing, I have 3 very simple rules. I'm going to give you each an opportunity to speak to me if you wish, but speak only to me and not to each other. Don't interrupt the court, don't interrupt each other, and don't interrupt the witnesses that might be testifying for the other side. And please speak loud enough and clear enough so that we can get a good record of everything that's being said today. Excuse me. Now, one final comment before we get started calling the cases. If your particular case is one in which the petitioner and the respondent have a child or children in common with one another, while I understand that the issues of time sharing and support are necessarily intertwined with what's happening in this courtroom today, this is still injunction court. It's not family law court, and the appellate courts have discouraged me and you all from attempting to litigate the issues of time sharing and child support in these abbreviated proceedings. My main objective today is to determine whether or not a protection order should be entered or not. I'm not taking testimony to make a determination concerning the best interests of your child or children, or to determine what the appropriate long-term permanent parenting plan or support measure would be in your particular case. Now, I'm happy to do that. I'm happy to do all of those things, but it would require one of you filing a case in family court to have those matters addressed on a long-term permanent basis. So if I determine, based upon the evidence presented, that I'm going to enter an injunction in your case today, and you do have a child or children in common, I'm going to give you an opportunity to step outside the courtroom with one of our court-trained, court-certified mediators to see if the two of you, with their assistance, can fashion a temporary solution as it relates to your children and to support until one of you can file a family law case. If you can, then the mediator will memorialize that agreement in writing, and I will make it part of this injunction. If you cannot agree, then you will come back into the courtroom, and I will decide those issues for you in a very short period of time, and the reality is you'll both probably hate what I do. So please take advantage of the opportunity to use the mediation services. It's the only time those services are free to you. Additionally, our mediators have no interest or stake in any particular outcome. They're simply here to help you all explore solutions, temporary solutions to your specific situation. So again, I urge you to take advantage of that opportunity. And with that, I thank you for your attention, and we will now begin by calling the first case.